Okay. Well, it's a couple of minutes past 10, so I think we'll get started and then we'll let others come through as they join. So welcome to our webinar today, which is looking at the practical aspects of allergens and the law. For those you that don't know Roythornes, we're a top 150 law firm, and we've really got a heritage in helping farming and food businesses manage the challenges that they face. Three quick housekeeping points before we start. Do pop any questions that you've got into the chat or into the questions, and we'll try and pick those up as we go through or at the end of the session. We will be sending a copy of the slides and a link to the recording of the video out in the next couple of days, so you might want to use it for for training amongst your teams. But of course, if you need any bespoke training, we can also do that. But we'll send that out so you can use it for training with your teams as well. And of course, we do have the details of the speakers at the end of the presentation. So again, if you've got any specific sort of technical questions, do get in touch with Hannah or Rebecca after the event. So our presenters today are both from our well-respected regulatory team, and they both spend a lot of time advising food businesses on regulatory issues. So partner Hannah Leese advises in respect of any regulatory enforcement actions by the FSA, DEFRA, trading standards and local councils. She regularly assists with criminal investigations, including attending interviews under caution and defending criminal prosecutions, both in Magistrates' Court and Crown Courts. In addition to her criminal work, Hannah's also involved in challenging the decision-making of both the FSA and DEFRA in civil proceedings, such as appealing against the service of inappropriate enforcement notices or bringing claims for judicial review where it's considered that these departments have acted unlawfully, for example, in respect of charges levied against a business for the supply of FSA staff. Our second speaker is Solicitor Rebecca Ironmonger. Rebecca advises and defends food businesses, farmers and house builders where they're faced with adverse decisions, enforcement actions and prosecutions by local and national government, again including the FSA, DEFRA, Environment Agency, Trading Standards and local councils. Her key specialisms are in animal welfare law, food law, environmental law, waste, water and pest control. And Rebecca's work includes challenging enforcement notices in the tribunal and magistrates court and advising on criminal investigations and prosecutions in the magistrates court and crown courts and challenging decisions by way of judicial review in the High Court. So two very talented speakers, and a very interesting topic. We're sort of 2 years on from Natasha's law and the impact that had on the food sector. So I hope you're going to enjoy the webinar. I'll be back afterwards to handle any questions, but I'll hand over to Hannah now, who'll start the webinar. Thank you.
Thank you very much, Mark. Can I have my first slide, please? Mark's in charge of the tech, so if it all goes wrong, we can blame him. That's great, thank you. So firstly, thank you very much, everybody, for attending this session this morning. Rebecca and I are delighted to have this opportunity to present to you. We're going to be taking you on a whistle-stop tour of the law of allergens. We're going to discuss some of the common breaches, what the consequences of breaching the regulations are from a legal perspective, and hopefully give you some hints and tips on what to do if the worst happens and you find yourself in a position where a food you've produced is placed on the market and where you've failed to include an allergen on the label to that product. The format of this session is going to be using 3 case studies to explore the topic. 2 of those are based upon legal cases that Rebecca and I have dealt with, and the third is an interview that I've undertaken with the mother of a small child with a very severe lactose intolerance. What we're hoping to do is give you a 360-degree view of the law relating to allergens from a business, consumer and legal perspective. And we've received some questions from attendees in advance, and we'll be answering those questions both throughout the session and at the end. But as Mark said, if you have any questions at all, please pop them in the chat and we'll do our best to answer those at the end. Now, just before we get started with our case studies, I wanted to set the scene a little bit. Now, I'm going to be deliberately controversial and perhaps even a tad inflammatory while I take you through my short introduction. And I'm doing that on purpose because I want to get you all thinking. I want to generate a bit of debate. And I hope to give you all a different perspective on things, which I hope is going to assist you when you come to review your food safety systems. So next slide, thanks, Mark. So this quote then, lawyers are the only persons in whom ignorance of the law is not punished. Well, that's absolutely fantastic news for Rebecca and I, isn't it? But unfortunately, it absolutely does not apply to you guys. You have got to comply with each and every food regulatory requirement which the law places upon you. Otherwise, you not only risk criminal prosecution, but particularly in the context of what we're talking about today, allergens, you risk causing serious injury or even death to somebody. So this is really, really serious stuff. Now, Rebecca's going to be taking you through some case studies in a little while, and she'll be explaining the sorts of things that can go wrong, and she'll give you some hints and tips on how to avoid those issues arising, as well as some hints and tips on what to do if the worst does happen. But I have to say, I don't envy your position at all. Next one, thanks, Mark. And the reason I don't envy your position is because the reality is that as a food business, you can never, ever guarantee that the food that you place on the market is safe. Because the only way that you can do that is to test every single gram of food. And then because of all of the food will have been taken up in the testing, there'd be nothing left for anybody to eat. So that, of course, just isn't practically possible. And so you're working in an environment where you must ensure that the food you produce is safe, but where this is, as a matter of fact, an impossibility. And in terms of allergens, the law places yet another burden on you, because not only must the food you produce be safe for the general population, so I mean it mustn't contain listeria or it mustn't have a physical hazard like a piece of metal or a piece of plastic in it, but you must make sure that your food correctly identifies allergens so that you ensure that an allergy sufferer doesn't inadvertently eat something which does contain an allergen, which makes that particular food unsafe for that particular person. So in addition to it being impossible for any FBO to guarantee that the food it produces is safe, unfortunately, I'm also of the view that the law surrounding allergens is also fundamentally flawed. Now, Rebecca's going to be highlighting later on key areas where FBOs have failed to properly implement Natasha's law. But it isn't just a failure to implement those new rules, or indeed the older labelling rules, which have been in place for some time now, that's the problem. The law itself is fundamentally flawed because it is premised on the basis that an FBO can guarantee that the food it produces is safe. And as I've already said, the only way you can do that is to test every gram of food, which would mean there would be nothing left for anybody to eat. So it's simply not possible. But in addition to that problem, the food industry is run and operated by people. Lots of excellent people, I might add, all doing a fantastic job. And Rebecca and I get to work with these people every day. But people are human beings, and human beings make mistakes. Nobody gets it 100% right 100% of the time. And if you're an allergy sufferer and you don't appreciate that whilst the law might require the presence of allergens in food to be clearly displayed on the label, through no fault of anybody, sometimes this just doesn't happen. And if you don't understand that, you're in a very precarious position, because no law can ever guard against human error. And a law that gives the impression that allergy sufferers can place total reliance and faith on a label is, in my view, extremely dangerous. Next slide, thank you. So the regulations do envisage that things will on occasion go wrong. That's why there are all sorts of obligations set down on FBOs in terms of food withdrawals and recalls. But what happens when it all does go wrong and an unsafe food has been placed on the market? What's the government's role in protecting people? So the food law regime that we have today all came about following the BSE crisis in the 1980s and 1990s. And that crisis marked the turning point for food and feed law, and it changed absolutely everything. And from it, we've developed the very complicated regulatory landscape that we have today. Now, I've been listening to a Radio 4 podcast series called The Cows Are Mad, which is absolutely brilliant. I'd encourage you all to have a listen. And in one of those episodes, Sir Richard Packer, who was the permanent secretary smack bang in the middle of the BSE crisis, described the UK government's handling of that crisis. And he said this: it wasn't poor and it wasn't very good. It was somewhere between satisfactory and good. Now, I find that an absolutely remarkable statement, but I do admire his honesty. But of course, the hypocrisy of that truth is really quite staggering. Because as a food company, you're expected to achieve the gold standard of only placing food on the market which is safe, even though, as I've just been discussing, that's actually an impossibility. Whereas the government, when handling a food emergency, and let's remember that's where there's an actual risk to human health that's been identified, all it needs to do is be a little bit better than satisfactory. And one might query why the bar is set so high for the food industry, if when faced with an actual emergency, and as we've seen, that can never be entirely avoided, the government is permitted to allow human health to be actually compromised by it failing to take adequate steps to protect human health, because all it needs to do is be a little bit better than satisfactory. And Rebecca and I have seen this very recently in respect of allergens. We both had a blog come up on our LinkedIn feeds a few weeks ago, where a very distressed mother had attempted to report a product which was mislabeled and which she had fed to her son and which had caused him to suffer a severe allergic reaction, only to find out that the FSA's online reporting tool doesn't actually work. And this poor lady, after an awful lot of toing and froing, finally managed to speak to the FSA via their alerts telephone line, only to be told by the FSA person she was speaking to that they couldn't get the system to work either. So this was a product which was known to be mislabeled, had caused a severe allergic reaction in a child, and yet the FSA appeared powerless to even note the incident, let alone alert the general public to this food safety risk, which is something that they're required to do under the regulations. And I guess if all the government has to do is be a little bit better than satisfactory, then that's all fine. But it seems pointless to me to place such a high burden on industry if government is not going to hold itself to the same high standards when dealing with a food emergency. So my next one, thank you, Mark. And so this is the legal position as I see it. And I am being a little bit tongue-in-cheek and I am being deliberately controversial. It's impossible for you guys to ensure that all the food you produce and place on the market is safe. It's impossible for you to therefore ensure that allergy sufferers are protected. But the law gives the impression that allergy sufferers are protected. And when it all goes wrong, all the government needs to do is be a little bit better than satisfactory. And so against that backdrop and that legal minefield that you guys have got to navigate, I'm going to hand over to Rebecca, who's going to take you through some case studies, which we hope will highlight in a practical context when things can arise with allergens and what you guys can do about it if and when they do.
Thank you, Hannah. Next slide, please, Mark. Thank you very much, all of you, for coming. As Hannah said, I'm now going to take you through two case studies, which I hope will illustrate some of the issues that Hannah's discussed in a practical way, as well as help to explain some of the things which can be done to assist you. So our first case study is about ready meals being sold which contained an undeclared allergen. In this example, a business produced 500 lasagna meals, of which 400 were ordinary meat lasagnas and 100 were to be gluten-free meat lasagnas. The information available, both on the order form on the business's website and on the label affixed to the finished products, did not declare cereals containing gluten as an allergen for the 100 gluten-free meat lasagnas. The chefs in the business made the 400 ordinary meat lasagnas first, put all of the ingredients away, and cleaned and sanitized the surfaces. Then the chefs took out the ingredients to make the 100 meat-free lasagnas. Unfortunately, the employee in charge of fetching the gluten-free pasta accidentally picked up the package of pasta sheets used for the first 400 lasagnas. Next slide, please, Mark. So to break down this case study into what the problem with this was and what happened next, we have to go back to the law. So what does the law require? The Food Information Regulations 2014 implemented the EU regulations, which place new requirements on food businesses to provide information on allergens in the food they sell or provide. Under these regulations, food businesses are legally required to declare the presence of any of the 14 allergens in any food they sell or provide. The 14 allergens are those in the second bullet point on the slide in front of you. In this case study, the relevant allergen is cereals containing gluten, specifically durum wheat. So the packaging and the online order form should have said wheat. However, as we're going to go on to say, these particular 100 what was supposed to be gluten-free meat lasagnas did not declare the presence of gluten in the pasta sheets because of the error that had taken place earlier in the day. Any product which does not have a declaration of the presence of allergens it contains from the list will be deemed to be unsafe. Placing unsafe food on the market is a criminal offence. There are more specific offences which can be charged under the Food Information Regulations 2014, which cover not declaring the allergen in the ingredients list and other labelling offences. In addition to those labelling offences and the placing unsafe food on the market offences, businesses will often be investigated and charged for more procedural type offences, such as not having the correct or sufficient training, supervision or procedures. We'll go on to discuss some of those later. Next slide, please, Mark. So what happened next? We know that in this case study, there are several potential criminal offences arising from the circumstances of the mistake. However, in order for the local authority to prosecute a food business for these offences, there are several things that will happen after the error occurs in order for them to prosecute. First, the mistake has to be discovered. Hopefully, any control measures in your business will catch the error before the product leaves the kitchen or factory for delivery and sale. However, where it isn't caught, it will often be a member of the public who will discover the mistake when they get ill from eating the product. This is unfortunately what happened in this case study. A consumer ate the lasagna, which should have been gluten-free, and fell ill. They contacted both the business and the local authority. This is the common course of action. Usually, either the business or a consumer will notify the local authority of the incident, and then they will begin to investigate. In the meantime, where you discover such a mistake has been made, you will need to notify all customers who have purchased the product and recall any uneaten products. The local authority investigation may include attending your premises, seizing products, and reviewing your procedures and paperwork. If the local authority decides that you or your business is suspected of committing a criminal offence, they will usually invite you to attend an interview under caution. If that happens, always seek specialist legal advice as soon as possible. The local authority might also serve an enforcement notice, requiring you to do certain things to ensure the breach doesn't happen again. We would always encourage you to seek legal advice and appeal the notice if you do not agree with it and there are grounds to do so. Next slide, please, Mark. If the local authority is satisfied that there has been an offence or offence is committed, that they have enough evidence and that it is in the public interest to prosecute, then they will commence proceedings in the local magistrates' court. You will receive a summons, usually with a cover letter from the local authority, listing the charges and showing a hearing date. This is very serious at this point, so even if you haven't received legal advice at earlier stages since the incident, get legal advice as soon as the summons lands. In this case study, the local authority charged our client with placing unsafe food on the market, not declaring the presence of allergens, and not having sufficient training and procedures in place. There were 4 charges on the charge sheet. After the summons is received and you have instructed a solicitor, the solicitor, and sometimes a barrister, will advise you on the strength of the evidence against you and your case. From that, you will need to decide whether to plead guilty or not guilty. If there are multiple charges, then you might be able to come to a plea deal with the prosecution. If you plead guilty, then the court will move on to sentence, sometimes at the same hearing, but most often at a separate hearing at a later date. If you plead not guilty, then the case will be set down for trial. Depending on the number of witnesses and the complexity of the case, the trial could take several days. If you are found not guilty on the conclusion of the trial, you will be acquitted. If you are found guilty, you will be convicted of the charges and later sentenced. Next slide, please, Mark. So what happened to the business in case study 1? This case study was based on a case I dealt with for a client earlier this year. On advice, we negotiated a plea deal where the business pleaded guilty to 3 of the 4 charges on the basis that the prosecution dropped the last charge. My client was fined £10,000 plus costs and the victim surcharge. This was an excellent result, as the fine could have been significantly higher. The mitigation presented at the sentencing hearing was vital and helped to bring the fine down significantly. Fines are calculated on the basis of 3 things: turnover, or income of the defendant; culpability, which is basically how wrong you were when the offence was committed; and harm, which also includes risk of harm. The prosecutor will always seek the highest culpability and harm categories that they can get away with on the evidence. Our task as the defence is to persuade the court to downgrade the culpability and harm to a lower level. The difference between categories is often thousands or tens of thousands of pounds, even for small businesses. Next slide, please. So what could the business have done to prevent the breach and ultimately prevent the prosecution? In truth, as Hannah described earlier, there is no way of completely preventing allergen incidents, as your business is only as good as your least competent employee on any given day. We are human and we make human errors. What you can do is reduce the likelihood of a mistake being made and, crucially, of that mistake being placed on the market. The first thing you can do is tighten up your processes and procedures with allergens in mind. You should be asking yourself these questions. How many checks are you doing? Do you have more than one employee checking each product and ingredient? Do you have set recipes which are checked with every delivery of new ingredients? Are your procedures written down, and are your staff reminded to do the checks? Do you have a documented procedure for what to do if something does go wrong? The second thing you can do is ensure that your processes and procedures are being followed and that you are monitoring compliance yourselves. Have all the checks for each product been made and recorded? Are those check results in an easy-to-read place and format for your staff, preparing, packaging, labelling and loading the food products? Do you have spot checks for your staff on operating days? Do you carry out an internal audit? The third thing you can do is to ensure that every member of staff preparing or handling food products is fully trained in food hygiene and allergens generally, and in your own business-specific procedures. Do you have refresher training for your staff? Do you have enough management staff trained in HACCP-based principles? Do you have all that training recorded somewhere? Are you pairing any inexperienced staff with experienced employees? All these things, as we have already said, are not foolproof, but they will reduce the likelihood of an incident and will be incredibly useful as mitigation or potentially to support a due diligence defence should you be prosecuted. In this case study, the business had some systems and procedures, but they were not as good as they could have been. One main thing which was absent was additional checks by both staff and management and pairing different members of staff. Even the local authority, prior to the incident, deemed the business's procedures were compliant with the law, but that was not enough to protect the business on prosecution. Next slide, please, Mark. I'm now going to move on to our second case study, which arises out of Natasha's law. Natasha's law applies to all food products which are made on the premises in which they are to be sold and are pre-packed for direct sale to a final customer or mass caterer. This is mainly applicable to places like sandwich shops or supermarkets which have an in-store bakery, for example. Natasha's law has been in force for just over 2 years now, and we will be exploring its impact later in this webinar. In this case study, we're using the example of a simple sandwich shop. There must be allergen information readily available on request in relation to sandwiches made to order, and the pre-packed sandwiches need to have a label with a full ingredient list which emphasises any allergens present in the sandwich. That's Natasha's law. This is the same requirement as for any pre-packed food made outside the premises and sold in the sandwich shop. For example, if the sandwich shop also sells those little individually wrapped cakes and pastries they sometimes have on the counter. In this example, the pre-packed sandwiches, which were made in the sandwich shop's kitchen, did not have a full ingredient list, although the allergen information was available on request. Essentially, the sandwich shop in our example had not changed its procedures or offering since this introduction of Natasha's law. This was due to ignorance of the new law. Next slide, please, Mark. The FSA carried out a survey earlier this year to assess the impact of Natasha's law since its introduction. The results showed that the situation in our example sandwich shop is not unusual. As you can see from the figures on the slide, a quarter of food businesses surveyed admitted they are not compliant with Natasha's law yet. This is mainly due to either misunderstanding of the rules or the cost of implementing the full ingredient list. This is a good place for me to answer a question which was sent in by one of you in advance. That question was, is there any data on how many businesses are non-compliant with Natasha's law and the enforcement action and/or prosecutions taken by local authorities in relation to Natasha's law? We have the figures that are on the slide in front of you. Also in the report, there was another piece of information. Some local authorities reported escalating incidents of non-compliance and taking enforcement action. Written warnings had been issued by 40% of local authorities, improvement notices had been issued by 8%, and cautions had been issued by 2%. However, it was more common for local authorities to respond by signposting food business operators to guidance or support, that was 91% of local authorities, or by providing written or verbal advice, 86% and 84% respectively. Many local authorities explained that their focus for the first year of the Natasha's law requirements had been to educate food business operators and support them with compliance rather than pursuing enforcement. Local authorities reported that enforcement actions and non-compliances increased by 32% since the introduction of Natasha's law. Natasha's law is undertaken by enforcement is undertaken by individual councils across the country. So there is no complete data set on that that's up to date. So the only figures we have at the moment are the FSA's report from earlier this year. In terms of prosecutions, given the law is still quite new and many businesses and councils are struggling to understand it, there are unlikely to have been many prosecutions so far. However, as time passes and environmental health officers make more compliance visits to premises, we are likely to see prosecution instances increasing. The leniency of local authorities will already have begun to reduce, as the businesses will have been expected to have tightened up on compliance over the last 2 years. Next slide, please. So what did the local authority do in our case? As I just explained, the data from the FSA's report shows that the most common reaction to non-compliance with Natasha's law was written and verbal warnings, and providing guidance. Formal enforcement action is increasing, but which is a trend which I anticipate will continue. However, it's not the common response at this moment. The local authority will generally look at the compliance history of the business, whether there's been any previous warnings or enforcement, before deciding on their next steps after a breach is discovered. In this case study, the local authority decided that as the business did not know about Natasha's law and their previous compliance history was good, they just issued a warning letter and provided guidance to the business on how to comply. However, if upon return to the premises they found non-compliances or no improvements, then they would then at that point serve an improvement notice. An improvement notice is a formal enforcement notice, which it would be a criminal offence to fail to comply. I hope that's been helpful. I'm now going to pass you back to Hannah, who will reflect shortly on the case studies before going on to discuss the consumer perspective. Thank you.
Thanks very much. Can I have the next slide, Mark? Thank you. So in an attempt to preempt what I thought might be some of your questions following on from Rebecca's case studies, I've posed myself 2 questions. The first is, could you ever successfully defend a case when you fail to declare an allergen? Now, unfortunately, in the circumstances that Rebecca described, this would, in my view, be very unlikely because there was a human error which could have been avoided, which led to the breach. However, things may be different if the lasagna sheets that went into that lasagna were themselves labelled as gluten-free and where the business in question had done everything it possibly could to avoid the commission of the offence. In those circumstances, the company may be able to mount a due diligence defence. Now, due diligence is extremely difficult to succeed in. And as lawyers, we often joke about it because in order to succeed in that defence, you need to basically have done so much so that you avoid the commission of the offence in the first place. And if you haven't committed the offence, then of course you wouldn't be prosecuted. The burden is really very, very high. But if you want to successfully mount a due diligence defence, then obviously due diligence is key. And for me, traceability is really the key to all of this. Responsible businesses will know about their supply chains. The obligation under the regulations is to be able to trace one up, one down, but many businesses that Rebecca and I deal with do far more due diligence than that. A real understanding of the whole supply chain is extremely beneficial because it allows a more holistic approach. I can think of a recent case that I dealt with, which concerned feed, but the principle applies equally here, where one of the ingredients going into the feed was potatoes. Now, my client believed that those potatoes were grown in Germany, but following an incident which prompted some additional investigations by my client, they actually discovered that these potatoes were originating from Russia. Now, had my client have known that, they may well either not have sourced the potatoes from that supplier at all, because the storage and facilities in Russia are not perhaps as good as they would be, say, in Germany, where we believe the potatoes were coming from, or at the very least, they would have done some more due diligence on the supplier. Reputable suppliers will be happy to provide you with paperwork, allow you to attend their premises and inspect their operations. And where suppliers are reluctant to allow you to do that, it suggests to me that there might be an issue. Undertaking your own independent testing of ingredients to check they are what they say they are is also important. I'm not suggesting that you have to test everything all of the time. The cost of that would probably be prohibitive. You wouldn't be able to do it. But I do think that random testing throughout the year will afford you a degree of protection. It not only demonstrates that you're not just prepared to rely on your supplier's word, and instead you want to go above and beyond to ensure the ingredients you're using are safe and not otherwise harmful. But as Rebecca was saying, it may assist you in terms of putting forward a defence if ever we get to that point where something harmful has been placed on the market. The more you've done, i.e. if you've taken all reasonable steps and exercised all due diligence, then that will help you in putting forward a due diligence defence. Even if relying on the defence of due diligence isn't available to you because there was more that you could have done, then all of those things will greatly assist in mitigation and in bringing down any fine imposed by the court if you ultimately are prosecuted. It may also impact whether or not a prosecution is brought in the first place, because you have to question whether there is a public interest in prosecuting a business that's really been doing an awful lot to avoid commission of the offence. Turning to the second question, has Natasha's law improved the position for allergy sufferers? Well, I'm afraid I think this case study really underlines how the law is failing allergy sufferers, because not only have businesses failed to properly implement the rules, but local authorities are not enforcing breaches. We're 2 years on now. And if that's the case, I think it's imperative that allergy sufferers know that the law isn't being properly implemented and enforced. Working in the industry, I know it's a very risky business for allergy sufferers to rely upon Natasha's law, but do allergy sufferers know that? For me, having a law in place, such as Natasha's law, and then not properly implementing it is really the worst of all possible worlds, because you have a situation where the allergy sufferer could quite rightly believe that the food they're buying is safe for them, when actually businesses and local authorities know that not only is the law not being followed, but moreover, when there are breaches, they're not being enforced. So moving on to my case study now, it's the next slide, thank you, Mark. In preparation for today, and in an effort to give you a consumer perspective on the rules, I've spoken to a mum whose little boy has a very severe lactose intolerance. Now, the lady in question I spoke to is my cousin. She's 29 years old, she's married, and she's a primary school teacher. Now, her little boy, Harvey, was born in May 2021, so he's about 2.5 now. And his mother soon realised that something was amiss. She was expecting her newborn baby to cry, but she wasn't expecting him to cry non-stop for the first 3 months of his life. Now, it took months and months to get a diagnosis, but finally he was diagnosed as having a severe lactose intolerance, and he was prescribed specialist milk by the doctor, and all was well for a while. That is, until weaning, and then the nightmare for this family really began. They began by checking the label of every product that they purchased, but they soon realised it was foolhardy to trust the labels alone. She gave me a very recent example of a popular brand of crisps sold in tubes, which her dad purchased the other day when he was going over to look after Harvey for them. Now, milk was not on the English ingredients on the packet, but when her dad arrived, both her and her husband said, "I don't think Harvey's allowed to eat those," because over the last few years, they've built up a bank of knowledge of what he can and he can't eat with a view to trying to keep him safe. So they looked more closely at the label, and her dad was right. There was no milk listed in the ingredients in English. And it was only because her husband speaks German he could identify that the crisps did actually contain milk, because there it was listed in the German ingredients. Ellie told me about all of the problems that she had when food companies changed recipes and didn't tell anybody. And she fully appreciates that all of that information is there on the label, usually. But she says there just isn't enough hours in the day to check every single label of every single food every time she goes to the supermarket. She says she's had to join mum's forums just to keep up to date with what she can and can't feed her son. The day that I spoke to her, which was just a couple of weeks ago, there had been an issue at nursery where, and I promise I'm not making this up, but it must be something to do with lasagnas. The nursery had fed Harvey a lasagna that not only contained full-fat milk, but it also had cheese on it. And the nursery admitted that this was down to a human error at the nursery, but my poor cousin was left with a very, very poorly 2-year-old boy for quite a number of days. She told me that she prefers the free-from labels. She said that they are clear, and in particular, she found Asda was excellent in terms of their labelling and the range of foods. She told me about how time-consuming it all is, how confusing, how burdensome, and how unclear. She says she'd much prefer a legal framework which promoted the use of the free-from label, or even a different type of assurance scheme. She just said, for example, allergy assured, which would make her decisions about what to buy far simpler, and she could rest assured that she was feeding her son something safe. But she did say how worried she was about how much of a premium businesses would add to products if they were allergy assured. She gave me another example of a very popular biscuit, which is 2 round circles with jam in the centre, where a normal pack of those biscuits is 75p, but a free-from packet is £2.75, despite the fact that the normal biscuits don't contain milk anyway. She said that other than free-from food, she was forced to buy vegan because that was the only way that she could be sure that the food was milk-free. This was far simpler, and she felt she could rely on the vegan label. Finally, she spoke about the fact that her son is not anaphylactic, thank goodness, because she said she'd never sleep another moment if he was, because she could never be sure that she wasn't feeding him something dangerous. She's lots of friends now who she's met via these online forums that she's had to join just to keep abreast of things, whose children do have very severe allergies. And she said that those parents spend every waking minute terrified that their child would inadvertently consume something which could provoke severe anaphylactic shock. So there we have it from a consumer perspective. It seems to me that the law presently does very little to assist my cousin, and instead it really merely overburdens industry. And I mentioned in my introduction that it seems to me that allergy sufferers are perhaps given a false hope that the food will be as described on the label. But as my cousin learned pretty early on, it was foolhardy just to trust the labels. And ironically, as a consumer, you need to do far more due diligence than that. For me, that's a pretty important message that allergy sufferers both need to hear and need to understand. So now, having heard about it from both a business and a consumer perspective, I'm going to pass you back to Rebecca, who's going to take you through our top 5 tips on how you can comply.
Thank you, Hannah. Next slide, please, Mark. So, pulling together all our advice from this session, these are our top 5 tips for reducing the likelihood of an allergen incident in your business. These will also help to perform any defence or mitigation if there is an incident. First is training. You are only as good as your worst employee. Ensure both those in management roles and those employees preparing, packaging and labelling your food products are trained in allergen awareness requirements and procedures. Second is procedures. Make sure your hazard analysis and critical control point, HACCP, procedures are up to date and comprehensive. It should be clear what constitutes a breach and what corrective actions are required to bring any process back under control. Third is records. Keep comprehensive and accurate records. These should include a record of your compliance with your HACCP procedures, the details and results of any quality checks, recipe cards, staff instructions, associated training, as well as ingredients lists, allergen information for each product. The paperwork will be critical if, despite your efforts, there's an incident down the line. Fourth is information. Food business operators must declare the presence of any of the 14 key allergens where they are used as an ingredient or in the processing of the food product. There are different requirements for the declaration depending on the product and its mode of sale, as we discussed earlier. Ensure you are providing all the correct information and necessary information to consumers and others further down the supply chain. As Hannah explained earlier, it's also very important to know your entire supply chain as well as you possibly can. Lastly, advice. If you're concerned about your procedures, records, or allergen issues generally, seek expert advice. If you have had an allergen incident, have received any enforcement action, or are being investigated, please contact us and we'll be happy to help. We're now going to answer some of your questions. We have had 2 questions in advance, which we're going to answer first, and then I'll pass it over to Mark, who's going to have a look at the chat so we can answer some of those questions as well. So the first question we had in advance, other than the one I answered earlier, was how many allergen incidents are there and how often are they prosecuted? So as I said earlier, as enforcement is the purview generally of individual local authorities, there is no national data set on prosecutions or enforcement. Prosecution for allergen labelling issues will generally arise out of an incident which has occurred rather than in isolation, but this is not always the case. Risk of harm is sufficient to give rise to a public interest in prosecution, and if food is placed on the market in breach of the labelling regulations, it is capable of prosecution without an underlying incident. What I can tell you about data is that the FSA deals with informing the public of allergen recalls and withdrawals, where, of course, the FSA website, as Hannah explained earlier, actually works. So the amounts I'm going to give you now are likely to be significantly lower than actual allergen labelling issues. According to the FSA website, as of yesterday, the 21st of November, there have been 213 allergen alerts since the 5th of July 2019. The most common allergen recalls were in relation to undeclared milk, gluten, and soya, although there were allergen recalls in relation to all of the other key 14 allergens. If you want to get the data for your local authority, you can make a Freedom of Information request of your local authority, and they will then have to supply that data within a certain amount of time after making the Freedom of Information request. The second question that we got in advance, which Hannah's going to answer in a moment, was what are the main breaches of allergen rules you see?
Okay, so the main breaches that Rebecca and I see are really exactly along the lines of the first case study that Rebecca set out. So where there has been a human error or where a procedure wasn't fit for purpose. Now, as we've said, you cannot ever entirely prevent human error, but you can ensure your procedures and checks are robust in an effort to pick up human errors before the products get to market and people get hurt. The real problem that you guys have, however, is that where there's been a human error, for example, the case study that Rebecca gave where the wrong pasta sheets have been used, or perhaps normal cheese as opposed to vegan cheese going onto a lasagna, the human who's made that mistake doesn't know they've made a mistake. If they did, they'd put it right. They believe they've made a gluten-free lasagna or a milk-free lasagna. And so why would they put a label on the product containing the word gluten or milk? Genuine mistakes will therefore likely go unnoticed because they're just that, genuine mistakes. The one simple step that I would suggest that I think may assist there is at the point when the ingredients are taken out in order to make whatever it is you're making, have somebody else go and check that the correct ingredients are being used. Now, I don't just mean get another member of staff there standing, chatting to the chef who's getting the ingredients out, distracting them. I mean somebody who is tasked totally with checking the ingredients are what are supposed to be going into the food. It's entirely impossible for you to eliminate human error, but you can introduce additional measures to avoid those errors actually coming to fruition. Have we got any other questions, Mark? Have we got Mark?
I can see from the question and answer box, we do have a question.
Yep. Okay. Yeah. And so that we have a question. It says using a specification from a supplier, and it ticks may contain an allergen, and you're an allergen-free site. How do you label your packaging? Do you bring that product onto site, and what do you place on the back of your packaging?
Goodness me, lots of questions in one. Using a from a supplier, it ticks many. Well, I think that potentially raises lots of issues, because I know, for example, businesses that operate as, say, a gluten-free site or a nut-free site, you absolutely can't bring allergens of that sort onto the premises at all. And so if you've allowed an allergen onto the premises that shouldn't have been there, I think you're in a position where you would need to basically go right back to the beginning, start again, clean and disinfect, and get yourself back into a position where you can say that it is the allergen-free site, would be my advice. Anything else to add, Rebecca? Does that cover it?
I think that pretty much covers it, yeah.
Yeah, good. I can't see any other questions. Oh yes, yeah. Sorry, we just got another a late question. Can you comment on alibi labeling and how well it mitigates companies if they are prosecuted? Are we aware of?
In terms of that, you talk. Sorry, whoever's asked that, you're talking about the precautionary allergen labeling.
Yes.
Is that somebody's just said yes?
Yeah, yeah.
I think all of the everything surrounding precautionary allergen labeling is really tricky, because you can appreciate from a consumer perspective that that labeling is really unhelpful. And my cousin said that. She basically said, don't even get me started on precautionary allergen labeling, the may contain, because what that really does is say to her that there's a load of stuff that she probably could feed to her son, but because it says may contain, she daren't feed it. And so it's a sort of get out of jail free card for a food business. But I can also see it from the other side, because if you're a business who really doesn't want to be telling consumers, because you're really not sure your product's going to be safe for them, it may contain an allergen, then I can see why a business would want to use that in terms of protecting itself. Now, I think there's been a recent report, I think it was the FSA again, in terms of precautionary allergen labeling, and it looks like they may be wanting to bring that in as a legal requirement. So you can only put precautionary allergen labeling on a product where there genuinely is a risk that it might have got into the food. You can't just put it on in an effort to save yourself. And the reality is that if you have a label on a product and it is incorrect, so there's an allergen in your food and it isn't on the label, ultimately the book will stop with you and you'll be in difficulty. I hope that answers that.
Right, brilliant. Thank you for that, Hannah. I can't see, excuse me, I can't see any more questions coming in. I would encourage anybody listening to get in touch directly with Hannah and Rebecca if you do have any questions. Their contact details will be on the slides that I send out. I do hope you found it useful. Obviously, Hannah and Rebecca are available for any questions or any in-house training that you'd like them to do with your teams, and anything in that in relation to that.
And also, sorry, Mark, just to cut across you. Rebecca and I and the team also do offer a free half hour. So if we can sort something out for you over the phone and it doesn't take more than half an hour, then it won't cost you anything at all. And if you call us with a problem, we can sort it out. Great, happy days. And if you call us with a problem and we say, oh, hang on a minute, this is actually a big problem, we need to look at this properly for you, we'll tell you about it, tell you how much it's going to cost, and you can make a decision as to whether or not you want to instruct us to do any work. But absolutely, call us up anytime. We're happy to help. And as I say, we do a free half hour.
There you go, brilliant. What a great way to end. So yeah, once again, thank you very much for coming. I hope you found it useful. Thank you to our speakers, and have a great rest of the day. Thank you. Goodbye.
Thank you very much.